So I'm Andrew. I'm also a Greg, and my paper looks at the cohabitant straight family homes. So what I'm looking at is in situations where unmarried cohabitants are living together and their relationship breaks down, what happens to the home they live in and the major assets. Before I get going, are there any law students in the crowd or law profs? No. Okay. I haven't mentioned any. I haven't included any like case names or major authorities, just for keep it simple in the interest of time. So I was worried about getting lynched. But okay, right. So why am I talking about this, and why am I talking about it here at this conference? Basically, there's been the last couple of decades. There's been a huge rise in cohabitating unmarried couples in England and Wales. In the last, since 2004, there's been a 30% increase in England and Wales. Represents about 30 million households. 3 million households. And there exist statutory property regimes in England and Wales for married couples and people that are civil partners, but there exists nothing for unmarried cohabitants. So essentially there's a hole or a lacuna in the law. These individuals are just not protected in the same way. And importantly and problematically, there's a belief that common law marriage exists in England and Wales, and that's just a myth. And so that belief it's a conception that over time, if you live together with someone long enough, you somehow gain rights and responsibilities akin to married or civil partners, and people believe that to their detriment, and that's quite problematic when it's relied upon. So due to parliamentary inaction, the courts in England and Wales, they operate on common law, so they can develop the law themselves piecemeal and incrementally. And they developed the common intention constructive trust to deal with these exact problems. So, and I think that the common intention constructive trust essentially disadvantages women. It produces substantive inequality, and it's problematic, extremely problematic. So the common intention constructive trust, when the relationship breaks down, the claimant usually is, in most cases, the female cohabitant, claims that they've got an existing right in the family property, so they're not looking for a remedy. They're saying, I've got a right in the home, and I want that actioned, I want it protected and recognized. It's a twofold claim, so you have to prove you've acquired an interest in the home. So you might not be considered legally the owner, but you have a beneficial interest. So your partner owns the home legally, but part of that is owned on your behalf for your benefit. So you have to prove first that you've acquired a beneficial interest in the family home. And secondly, when that's proven, then the court looks at the common intention of the parties to see what the quantity of that interest is. So it's not necessarily going to be a 50-50 split. Both of these hurdles, or both of the aspects of this test is problematic for a number of reasons. Acquisition of a beneficial interest, this is what most interests me, and I think is most problematic from a feminist point of view. First and foremost, cohabitants that have joint legal titles, so perhaps the property was purchased together. If both cohabitants are registered on the title documents, they're presumed at law to have equal division of property on breakdown of relationship. So they've automatically sort of satisfied this first requirement. What's more problematic is for non-title cohabitants. So what is more realistic is where one person moves in with another person who owns a home. And the only way, there's two ways that you can acquire beneficial interest if you're a non-title cohabitant. The first is through express agreement. It's extremely rare. I think it's unreasonable for two people sort of in the throes of love who've just moved in together to sit down after a romantic meal and say, by the way, let's kind of work out and pen out our legal relationship with respect to the home that I don't necessarily own. Anyways, it's rare. It's silly to think that people do that, and it doesn't come up in case law. So I'm not going to talk about it anymore. What is actually practically important, or what's seen as the only real way to acquire beneficial interest in family home, is through direct financial contributions. That's done first by contributing to the purchase price of the home, or contributing to subsequent mortgage payments. Other things that are contributions during the relationship that are not direct financial contributions will not satisfy the acquisition of a beneficial interest. So that, I think, is really problematic. We'll talk about that later. Quantification of a beneficial interest. So if you can prove that you've acquired beneficial interest, the court then determines what the common intention of the parties was to the shares. So if I can say I've got a beneficial interest, then I need to say, or need to prove exactly what is it, 50-50 split? Is it 90-10? What's going on? It's objectively assessed by the court in light of the cohabitant's whole course of conduct with respect to the property. And then where common intention cannot be identified, it can be inferred or imputed by the court, which is also problematic. So, what I think are the major problems with the common intention constructive trust, particularly the acquisition of a beneficial interest. It doesn't reflect what I would call a general economic inequality between men and women in society in England and Wales, which I think is evidenced through pay gap differences, the fact that we've got a lot of women who are engaged in domestic roles of some sort or another. It places absolutely no value on non-financial domestic contributions to family home, and I think that's the crux of the issue. So you have a lot of individuals, like you were talking about earlier, who are engaged solely in raising children or contributions to the home. If they haven't made a direct financial contribution, doesn't matter, they're cut out, so they fall outside of the scope. So even in a quantification stage, if you can prove that you've got some sort of acquisition, but you can extend your ownership through quantification, it doesn't matter if you can't make the acquisition hurdle. So it really cuts out a lot of people. And it ignores, it's totally ignorant of modern cohabitational relationships. So we've got a huge rise of cohabitation, and a lot of people it doesn't reflect division of labor. When couples have children, generally speaking, women actively choose to stay home to raise children, whether that's full-time or part-time. It doesn't matter to me. It still doesn't reflect that work. I think I've got it's about 60% of unpaid carers in England and Wales are female, and so their work, with respect, if they're cohabitants, just that work isn't valued. So to me, it seems like the court sees this as a gift or a responsibility that women responsibility that should be on the shoulders of women. And I think that's unreasonable and produces substantive inequality. With respect to quantification, I'm not going to talk about it as much because it's more a question of legal certainty. But how do you identify common intention as to ownership in a home over the course of a relationship? I know if common intention was judged at the beginning of a relationship, that would be significantly different than the last dying months of an awfully drawn-out relationship, right? So, I mean, how do you do that? It's not reasonable, right? At what point in the relationship? The concept of imputing common intention is inherently problematic. How do you impute common intention? That's not common intention. And the court does that more often than not. So, and problematically, there's no objective or there's no list of indica as to how the court comes up with what common intention is. So, so essentially, it is seen as potentially an objective assessment of fairness by the court, but we don't really know what fairness is. So it makes it very difficult for someone who's going through this process to potentially bargain in the shadow of the law to get out of going to court. It makes the process extremely long. It exacerbates litigation. So other major issues is that because of the uncertainty involved, claims are really expensive and claims are generally brought by female cohabitants. So it seems to me a very, very poor way to patch a hole in statutory property regimes, and it seems to me anyways to be particularly disadvantaged. It disadvantages women in a particularly bad way. So legislative reform. My paper compared this common intention constructive trust to the current frameworks in Canada, because surprisingly that's where I'm from. So basically in Canada we operate on a system of unjust enrichment, also developed by the Supreme Court there. There's subnational legislation which has basically entrenched these concepts, and it is very similar to the Cohabitation Rights Bill, which has been introduced by Lord Marks. It's a private member's bill. It's currently in committee stage in Parliament. But basically, the way it works is that you look at the relationship of cohabitation as a whole. You look at the end of the cohabitation. If one person is enriched as a result of as a result of the relationship being viewed as a single economic unit, then you look at the other person being or receiving a detriment as a result, and you just rectify that. So basically, instead of going to the court and saying, I've got a right in the property, you go to the court and you say, look, I'm subject to a particularly unjust situation as a result of my work, potentially domestic work in the home. The other partner has been able to have an unjust enrichment, and so I would like to be remedied for that. So it sort of changes the narrative and it changes the discourse, which can be potentially problematic. That's flagged up as an issue by a lot of feminists. It's looking at, instead of saying I've got a right to the home, you're sort of asking the court for something, and some feminist academics kind of see that as you've got sort of a weak female cohabitant coming to the court, sort of like begging for something. I see that as short-sighted, and I don't think it's a reasonable way to look at it, because in reality, practically, it enables a court significantly more remedies. So if you've got a common intention constructive trust system, basically you have a very high threshold for the acquisition of a trust. If you don't meet that, then you're cut out of it. So it cuts a lot of people out. Whereas if you've got an unjust enrichment system, the court can provide remedies which are monetary, and so it really reflects a whole range of relationships, because we exist on a spectrum of relationships. It's not just living like you're married or not being married. So it's significantly wider in scope, and claims under unjust enrichment aren't to do just specifically with the family home. It's any wealth generated. So a claimant potentially has a much larger pool of resources that they could be receiving remedy for. And I think that better reflects too that, you know, the idea of the cohabitation being a single economic unit. There's other assets involved in people's lives, not just the family home. And so that all needs to be taken into account. I think it would be a progressive step forward. I think it would be much better for women, and unfortunately, the last Conservative government said it had no interest in the Cohabitation Rights Bill, and I feel like the newly elected one probably not going to be, it's probably not going to be at the top of the priority list anyways. So that's the end of my presentation. Questions, comments, concerns, come at me.
That was so interesting, thank you. That was really fascinating. I've got just two comments actually. The first is when you said about the feminist understanding of women going and sort of asking the court for something, and you disagree with that sort of, you know, being a sort of passive woman going asking for the court. I would say I don't agree, actually. I agree with the feminist perspective on that. I think it's, for me, it's about the symbolism of that, and I absolutely get where you're coming from, that it does give the court a lot more options, but I think symbolically, I think that's a really interesting thing, that it's kind of women going and asking. But I mean, that's just my perspective.
Right, no, I see how the narrative, it potentially, I mean, that it changes the discourse, and that, I mean, so looked at in that specific way, maybe that's bad from a feminist point of view, but when you look at it practically speaking, yeah, right, it actually affords cohabitants who are engaged in domestic work significantly more remedies, and those individuals happen to be women, yeah, generally speaking. So I think, yeah, so maybe from an academic point of view, yeah, you're right, but for a practical point of view, especially, well, just, yeah, for your regular Joe on the street, yeah, they're going to want something.
Yeah, so. I think you picked on a really good point there, because I think what it is about the kind of level, if you like, at which you're kind of analysing that. You're coming at it from a really practical point of view, whereas I guess what I would understand the feminists coming at is from a very symbolic point of view, and the two aren't mutually exclusive.
No. And to be honest, there's so I guess maybe I phrased that wrong. That was just sort of one end of the spectrum of feminist.
Yeah, no,
there's like
of course,
so,
absolutely. But that's
that was
really
just my
interesting.
favourite one, I guess. So.
And I just have one other comment to make, if I can. I think you know, it's really interesting. I think as I showed earlier, you know, the kind of the discourses around marriage and people opting not to get married, and I think very often not getting married is seen as a really positive thing for women, that you're kind of casting off the shackles of this sort of, you know, really rigid sort of patriarchal institution, and is really embraced as, you know, you should cohabit because then, you know, you're not locked into this kind of traditional relationship. And actually what you've just shown is that that can be...
You're not casting off marriage, you're choosing to be excluded from a bunch of rights.
Absolutely, that actually can have really negative consequences, which many of which I absolutely wasn't aware of. So that was really, really interesting. I think it says a lot about the kind of status of marriage and the way in which marriage is kind of understood as protective or otherwise. So that was great, thank you.
Great, do we have any more questions?
Yeah, I wondered if I could come back to the first point that you made, which is very interesting, that common law marriage is just a myth. And I was wondering whether, even though it's just a myth and doesn't have any legal status, is there any precedent or track record in civil suits where non-married partners have broken up and one has tried to sue the other one for recompense? Is there any pattern of rulings that might suggest that people behave as if it does exist, or does it the absence of law purely stand as a form of persecution here?
That's a tricky one. So with respect to the family home, okay, let me think about that. With respect to the family home, there's no, you wouldn't be able to bring a civil suit there. But with other assets, potentially you could potentially bring in unjust enrichment claims with respect to other mutually owned or mutually owned assets potentially, or a business. So you got potential recompense there, but with respect to the family home, which is generally the major asset, no, you don't have any ability. Basically, it's a property right, and those are enshrined and really protected here in England. So you don't really have any ability. You've got no protection there. So otherwise, outside of that scope, maybe, but that's not really what I was looking at in my. I mean, I guess if there's a child involved, there'll be some ancillary relief with respect to what obligations you owe in maintaining that child. But outside of that, no, I don't think so. At least not that I've studied.
Okay, thank you.
Do we have any more questions? Yep.
Yeah, I was just wondering, you mentioned there being a kind of general pattern of there being one current partner and one domestic partner. Do you see that? Does it occur on the same level in non-heterosexual relationships as it does?
I didn't really look at that closely at that particular situation, but I would say that, and everything that I've looked at, I didn't look at it so gendered, but you're going to have one person that does more domestic work. If you have a child in your relationship, unless neither partner is working, somebody's going to be taking some sort of detriment to their career or other economic ways that they can make money by staying at home and raising a child or doing other work around the household. So someone is going to, and no matter what way you break it down, you always got a breadwinner or someone that's earning more and someone that's earning less. And so I think in non-heterosexual relationships, you still have that issue and you're going to still be able to make those claims.
Any other
Does that
comments?
answer?